Welcome back to another edition of CRA Sessions, a podcast from CRA. I'm Dave Duski, and with me again is Brian Nolan from Mayer Brown. Brian and I talked about AI and trade secrets in an earlier podcast. Specifically, that podcast focused on the role that AI has played as an inventor and a creator in trade secrets, and how companies are now looking towards trade secrets as a means to protect those inventions. But this episode, actually, I want to focus on something a little different, and that is, can AI pose real threats to trade secret protection? In other words, my understanding as a layperson is one element for something to be a trade secret is it cannot be readily ascertainable. So one could argue that, does AI make certain trade secrets readily ascertainable? And I'm curious to kind of get your thoughts on that topic.
Well, I think you've hit on another key issue, and thank you for having me back. I had a very enjoyable time last time up here at CRA and listening to your insights on how to maximize some damages awards, particularly if you're going to use trade secrets in the AI space. But we hear, as we discussed in that last podcast, that trade secrets are considered a very valuable tool in the AI space. But then there's doubters out there, other people that view this from a different perspective, and they say, considering the power of AI that we expect it's going to have, will it make everything readily ascertainable? And you are correct that when we look at what is a trade secret is any information that has independent economic value from not being generally known or readily ascertainable. And so if AI makes everything readily ascertainable, you would miss one of the pillars of a trade secret. I think, though, that you have to look at this from a perspective of what trade secrets are we talking about. So I'll break this up into two categories. There will be trade secrets that are associated with the AI model itself and the AI components. So that may be the algorithms, that may be the model, it could be the data sets that were used to train it. And it also could be the output of the AI. I think those are components of AI that each one of those you may want to use trade secrets with. Maybe a little more difficult using it with the output if the output's going to be generally known. We're up in Boston. I know there's a bunch of AI companies up here that are trying to make drug development. And obviously the output, that drugs are going to hit the market. So you're not going to use trade secrets to protect that. And so for the question becomes, is the data, the model, is that readily ascertainable? Because these are generative AI models that are set to give you this information. And then the second part we would look at is just trade secrets that are not generated by AI. They may be separate. They may be a formula. They may be something else. And the question is, can I use AI to replicate those formulas? And so I think you need to look at both of those independently because it has to be readily ascertainable by proper means. If you use improper means, then it's not readily ascertainable. And so for the AI models and algorithms and data, I think it will be important for people to use terms of uses and put conditions upon how the model should be used. There's a case up here, recently filed open evidence, in which they allege a competitor used prompt injection attacks to get their fundamental mechanism by which the model works. And they assert that using prompt injection to have the model divulge that information was improper means. Although not an AI case, there was a case in the 11th Circuit recently, CompuLife, in which scraping was done where a computer went in and pulled all information about insurance quotes, and that was found to be improper means. So I think that if you put appropriate parameters around your AI and your terms of uses, and we'll have to see whether courts say, putting those terms of uses in and violating those terms of uses, therefore made this improper means of acquiring the information. And they also, because you also have to take reasonable steps to protect those terms, and not just the terms of loan, but monitoring what's happening in your model and seeing if somebody's exfiltrating a significant amount of data, and then responding to that would also be, have you taken reasonable steps to protect? So in that instance, I think that readily ascertainable, you have some arguments against. On the non-AI trade secrets, say a recipe for a famous product out there. People do think that you can put in parameters and ask questions and prompt an AI system to reverse engineer or give you something that would be similar to what is out on the market. And that may be the case, but I think that may be a way to compete. But I don't know that you would know that you've acquired the trade secret, because it seems to me to be able to acquire the trade secret, you have to have some way to compare it. Mm-hmm. And so I think in that instance, you could make an argument, well, how did you get the information to compare the result of the AI? Or how did you get the information to know how to prompt the AI to develop the competing product? So again, I think if you look at what occurred, if you see that you can make an argument that there's improper means, then maybe it's not readily ascertainable. So again, we're looking at AI as it is now, and we see there's a significant development that's going on. In the future, maybe this changes, but right now I don't know that AI is going to make everything readily ascertainable. What I do find interesting, though, is I see AI as a way to compete better and maybe to develop things more efficiently. And I feel where I think that may come in is more in your area, where you're an expert, is how, I think last episode we talked about avoided costs, but looking at how much it would have taken the misappropriator to develop the competing product. There, I think AI could be a powerful tool, but I'd be actually interested to know how you would balance that if you were trying to defend a damages award or craft a response to a damages award where you had AI as a tool to maybe build in a competing product.
Well, I mean, that's very interesting. And just to be clear, accused misappropriators, when they're trying to rebut an argument of avoided cost, sometimes argue that the trade secret owner's actual cost to develop the trade secrets, although courts have allowed that to be used as a proxy for what the accused misappropriator avoided, sometimes may not be the most accurate measure of what those but-for costs would have been. So say, for example, you had a trade secret owner who spent 10 years developing a trade secret, but that occurred 20 years ago, 20 or 30 years ago, right? My understanding is when you're looking towards addressing the issue of potentially reverse engineering to develop an avoided cost theory or a head start period, you're looking at what it would take right now. So you could have differences in market dynamics. You could have differences in technology, for example, AI. And oftentimes accused misappropriators argue that, no. If we had to do this right now with today's technology and today's market, with the competition that exists today, it wouldn't have taken us 10 years. It would have taken us 15 months. And instead of $200 million, it would have cost us $1 million tops, or $500,000, something along those lines. So that is a common argument that we've seen for a long time. What I think is interesting, though, is how does AI change that now? Because AI, to my understanding, has some pretty, unique capabilities and is able to do things a lot quicker than us humans could do. So there's a potential, based on if certain evidence exists, that the use of AI could shorten any potential head start period, or in other words, the time it would have taken the accused misappropriator to lawfully develop the trade secrets. And also, it could also reduce the costs associated with that development. So a accused misappropriator may want to argue that with certain AI technologies, and this likely would, again, it has to be fact specific. You're likely going to need fact witnesses, other experts aside from damages experts to kind of weigh in on what exactly this would have taken, what would the output have been, would it have been maybe acceptable in the marketplace? A lot of factors, right, that you need to address. But Assuming that's all proven, it stands to reason that an accused misappropriator may put this forth in rebuttal to what could otherwise be a very large avoided cost number put forth by the trade secret owner. I think the problem that you could run into, and we've seen this in patent cases, I think, for years, when accused infringers look at designer-owned alternatives, non-infringing alternatives, is the disparity in the two damages numbers. So you could have a trade secret owner with asking for $150 million based on avoided costs, and then you have an accused misappropriator asking for $10,000. And what is the jury going to believe, assuming they get to the damages phase, which of course means they've already found the defendant to have misappropriated and engaged in alleged wrongdoing? And how do you balance that if you're working on behalf of, or you're representing the defendant, Brian? Like, how would you approach that situation to address that?
I think that's a very good point, and it's astute for you to raise it because your damage response has to be realistic and has to be something that the jury can grab onto, because where in patents you very well could have just an innocent infringer in the sense that somebody independently develops a product, is unaware that a patent is out there, or even is aware that the patent is out there but has strong arguments to believe that the patent is not applicable to their product, either from an infringement or a validity perspective, and they continue on. That's different than every trade secret case, because an underlying requirement of trade secrets is that it was acquired by improper means. Reverse engineering is fine, and independent development is fine. It's just acquired by improper means. So as you noted, if they're getting to the point where they're considering the number that you've presented versus a number that another expert has presented, if you're on the defendant's side, they've already decided that the side that you're on has done something improper, has done something untoward, in the sense that they feel like between the two, one is in the bad camp and one has been the aggrieved camp. So it is very important to balance those numbers. That being said, you're not going to artificially inflate your number just to balance it. It's just you really need to pressure test your assumptions, your analysis from a factual perspective. On a technical, factual perspective, I'm saying this could be done. Well, let's show how could it have been done.
Right.
From a economic perspective, because you could see somebody saying, well, it's not just using the AI. What happens if you had to make some modifications to the AI or made a bespoke AI model that would be able to do it? Then you'd have to look at, well, then do you have to incorporate some of the expenses in building the model and training the model? But again, I think you have to look at that holistically and say, factually, I can show technically it's capable of being done. It's reasonable from my financial perspective, and then balance that in a comparison, because I think oftentimes when you're on the defendant's side, you're looking to try to minimize that legal relief, the damages that are going to be presented. And where you balance that, because sometimes we feel like finders of fact will split between what the high end and the low end of something is. So one side tends to want the high end to be high, and one side tends to want the low end to be low.
Right.
But at some point, if the low end's too low or the high end's too high, it just becomes a non-factor because it gets disregarded.
Right.
So working again early with people like yourself to explain to us what's reasonable.
Right.
Like the corollary would be, from a patent perspective, a comparable license. If you're going to use a comparable license that's really low just to drive down the number, but that comparable license is not comparable, it can easily damage your credibility. And on the same side, if you take a comparable license that's high, that gives much more property or value, it can damage your credibility. And the last thing we want in front of a jury is to have our experts' credibility damaged or looked at as they're just shilling for one side and not really tying it in factually.
Right. Well, and you mentioned, earlier, and we talked about this last episode, kind of these larger damages awards that we're seeing. And obviously, we can't get into the heads of the jury. We're not in the jury room. We don't know exactly what they're considering and how they arrived at their numbers. But do you think that the evidence and the fact set that is exposed during trial, like if there's some maybe, I don't want to say incriminating emails, but bad emails or facts or testimony. In the Sintel Trezetto case, there was an email referring to a project that Sintel took and referred to it as the first kill. Like, do you think that influences juries when they're tasked with determining damages?
Oh, absolutely. I think that they get a view of the parties, who they like and who they don't like. And those are things they could grasp onto. Oftentimes in patents and trade secrets, this is highly technical, difficult, factual information and analyses that we ask them to do. And they do a phenomenal job dealing with it. But there are other things that they can look at that's just more in line with what they're used to in their day-to-day. And so when you see those internal documents that we loathe to see, and we always talk to our clients about training on what should be put in writing and how you should behave and how you should look at your competitors' work. Yes, it's one of the things that we know we're going to see them. It's just a matter of that they're going to come out in discovery and they're going to be front and center at a trial. And I do think, as you're noting, they will absolutely sway a jury, even if there's a reasonable explanation for why something was drafted the way it was drafted. It happens all the time, and it affects the outcome, in my view.
Yeah. I mean, I think this is really going to be interesting to see how it plays out in future cases, because there's not a lot that I've seen yet, at least, in the public domain, where accused misappropriators have put forth this kind of avoided cost theory based on AI and how they've tried to argue that, what courts or juries have thought of that argument. Because, like I said, it is very akin to the design around argument in patent cases. And you run into situations, I think, where you have this big disparity in numbers from both sides, and how do you reconcile it? How do you reconcile it with the question of, well, if it was so easy and you could have just used AI, why are we here? Why didn't you just do this from the start? And, of course, I could see the response from a misappropriator or a litigator like yourself arguing, well, because we don't think that these are trade secrets to begin with. But it's some interesting questions that I think are going to have to be addressed, going forward.
I agree. I think the courts are going to be very busy dealing with issues that come from AI, issues kind of in the sense that, like you just said, how does it affect damages and trade secrets? I think there's going to be some, from a patent perspective, some issues, how we look at concepts like obviousness. What is obvious now if you get to the point where AI can truly be as generative as it's supposed to be? So I think courts are going to be grappling with these issues over the next few years. And it's nice to be at the forefront and be able to work with people like yourself to develop these arguments and leave it to, the really strong federal judges that we have and state judges to articulate what the rule of law is going to be on these topics.
Yeah, no, I agree. And that's why I personally like trade secret cases, because of I think the latitude that's afforded in assessing damages and unjust enrichment, and kind of the creativity involved, and the fact that each case, is different and has very unique fact patterns to it. And what approaches can you use? Which ones do you not have enough evidence to put forth? And how can you argue what the ill-gotten gains were? And, I think it just makes all these cases very, very interesting from, an economic perspective. So there's certainly more to come. And I'm certain that this will not be the last we'll be talking about some of these topics. It'll be interesting in the coming years to, what important cases have come out and what we've learned from it. But again, Brian, I want to thank you for being here in Boston and joining us and sharing your thoughts with us. It's been a great conversation. and I look forward to keeping in touch and see how all this plays out going forward. Again, to learn more about CRA, visit our website, www.crai.com. Thanks, Brian. Great having you here.
Thank you for having me again.